And we begin with that breaking news out of Georgia this hour. Fulton County District Attorney Fani Willis will begin presenting her election interference case against Donald Trump and his allies to a grand jury early next week. The Atlanta Journal-Constitution is reporting the timeline came into sharper focus when former Georgia Lieutenant Governor Jeff Duncan and independent journalist George Sheedy separately confirmed that they received notifications they will testify on Tuesday. Now, this means the public might know by Tuesday whether jurors indict the ex-president and others. Tuesday evening, to be specific. Willis is expected to begin her presentation to grand jurors on Monday. We're going to have more on this breaking development later in the show. But we first begin with a reality check for the now thrice indicted ex-president. Donald Trump, quote, is a criminal defendant. He is going to have restrictions like any other criminal defendant. Those were the words of Judge Tanya Chutkan, the federal judge overseeing special counsel Jack Smith's election interference case against Trump. In a hearing yesterday, she rejected Trump's request to be able to speak more broadly and publicly about the investigation. In a new protective order, Chutkan limited the ex-president and his attorneys from publicly discussing any, quote, sensitive material turned over to them during the discovery process. And that includes, quote, any personally identifying information concerning witnesses, information that had emerged from the grand jury, and any materials turned over from other government entities. Now, during that hearing, Trump's legal team argued that too strict of a protective order would stifle the candidate's constitutional rights. But Judge Chutkan, well, she basically shot that down. Quote, Mr. Trump, like every American, has a First Amendment right to free speech, but that right is not absolute. It is an early blow to what is largely expected to be the centerpiece of Trump's defense during trial. Since this latest indictment dropped, the GOP frontrunner and his allies, well, they've kind of been making the rounds, and they've been arguing that the government's entire case is simply nothing more than a brazen attack on Trump's First Amendment political speech.
This is a free speech killing indictment. Killing free speech, that's what it is.
It's criminalizing speech for this reason. What the president saw in the 2020 election was all these irregularities going on. He had every right to comment on that and act politically.
You're entitled to question whether it was honest or not. That's the uniqueness of the First Amendment. That's the uniqueness of America. But you know what? You shouldn't be prosecuted for your thoughts.
Yeah, so here's the thing with that. According to legal experts, that's not actually a defense that holds any water. Legal experts say there is little legal merit to that argument, particularly since the breadth of steps taken by the ex-president and his allies to overturn the election transformed mere speech into action. I mean, Trump isn't being indicted for what he said about the 2020 election. He's actually being indicted for what he did, allegedly engaging in a criminal conspiracy to overturn the will of American voters. But Trump's First Amendment fallacy isn't just a shaky defense in the courtroom. There's actually growing risk that his refusal to remain silent could derail candidate Trump. And all this could be before he even gets to hit the campaign trail in earnest. Earlier this week, prosecutors from the special counsel's office put forward a proposed trial date landing on January 2nd. However, during Friday's hearing, Judge Chutkan cautioned that the more either party makes, quote, inflammatory statements about the case, the greater her urgency will be to speed up the trial date. The judge warned that even, quote, arguably ambiguous statements could be construed as intimidation or harassment of potential witnesses. Judge Chutkan ended the hearing with this promise, quote, I will take whatever measures are necessary to safeguard the integrity of the case. So there you have it, plain and simple. Judge Chutkan has laid it out in black and white, the exact parameters by which Trump must abide, which leaves us with this question. Will the ex-president actually listen? Will the judge's warnings fall on deaf ears? Right now, Donald Trump is playing with fire, and with every new speech or social media post he makes, he runs a risk of getting burned.